Welcome back to Canadian Justice, where we're discussing a case in front of the Supreme Court dealing with laws of evidence in sexual assault cases. Now, Mr. Chan, this case went to the Supreme Court because the constitutionality of this law was being challenged. What are the constitutional concerns, and how does it relate to, for example, the right to silence or other constitutional rights?
Right. So the constitutional concern really comes down to the principle against self-incrimination. That's protected by Section 7 of our Charter of Rights and Freedoms. And the right to silence is a component of that. But essentially, under Canadian criminal law, the way we've always done things is the accused is charged criminally. And because the accused is presumed innocent, the burden is on the Crown. The burden is on the state to prove the accused guilt beyond a reasonable doubt without the ability to force the accused to participate in that process. And so the accused is entitled to sit back and say to the government, you have to prove your case against me without any help from me. And that means the accused doesn't have to testify at trial. The accused doesn't have to give a statement to the police when they're being investigated. And it also means that the accused does not have to make disclosure of materials in their possession that they intend to use at trial, or reveal the defense strategy, reveal the line of cross-examination that their lawyers may take to confronting certain witnesses that the Crown may call. That's all part and parcel of this broader idea of the principle against self-incrimination. And the rationale for having this is because our law has historically recognized the tremendous power imbalance between the state and the individual. And our law recognizes that related to the presumption of innocence and related to the ability to make full answer in defense is this notion that the individual should not be conscripted, should not be forced to participate in their own prosecution. And so that's at its core what's at issue, we argued in this case, with this law that now requires the accused to make disclosure of the records in their possession before they use it, not just to the court, not just to the Crown, but also to the complainant, also to the essential Crown witness who they would be confronting with these records at trial in the ordinary course. In this procedure that this law has created, the complainant now gets the ability to object to the use of this evidence against them before this evidence is used. And as part of that process to see what the defense strategy will be.
So, Missing, what you were kind of on the other side of this issue with West Coast Leaf. What did your organization argue about the constitutionality of that law?
So West Coast Leaf and WAVA focused on sort of what Mr. Chan just touched on about complainant participation. And so there was a lot of concern that we could see that there was this idea that if the complainant was a part of this process and in having to determine whether or not these records could be used, that was in somehow a decrease in the rights of the accused. And so what we were emphasizing to the Supreme Court was that when you're looking at complainant participation, it means an actual promotion for the search of the truth, because you're preventing impermissible myths and stereotypes about sexual assault from infecting the trial process. And it was also an emphasis on how complainants, specifically those who face multiple inequalities and barriers, people whose backgrounds are often very different from the lawyers and the judges who are in the courtroom, how naturally having their voice heard in the determination of these records, that does not take away from fair trial rights, as opposed to enhancing and making sure that when we have these trials, that we're getting it right in terms of the balancing of everybody's rights.
Now, Missing, we've got about a minute left, but I want to differentiate this law from another type of law our viewers may be familiar with, which are parochial, commonly called rape shield laws. What's the difference between these two types of laws?
And so with the regime we're talking about records, whereas with what's normally called rape shield laws, you're talking about the prior sexual history. So the sexual past of the complainant and whether or not it's permissible to ask questions about that.
And for those that type of evidence, there is a similar procedure. Is that correct? Where you need to bring an application before a judge to admit that evidence?
Exactly. The idea is that before you can delve into those questions about a complainant's past, you have to be able to make sure that you're not asking the judge to tender that evidence with an eye to say that the complainant should be less likely to be believed because she may have a promiscuous past, what some would characterize as a promiscuous past, or that you're in any way advancing something that isn't actually relevant to an issue at the trial. So you have to be able to show that there's a reason why you're delving into this.